Hello and welcome to Robinson Moore Experts Talk podcast. Today we are going to discuss permitted development rights and I've got three experts with me. So I've got Abel, Bunu, who's Principal Planner. He's previously worked for the council and is very aware of how the local planning authority works and the process in which planning applications are determined. He's also highly experienced with the appeals and the process. I also have David Sawford. He's Partner and Head of Planning and Building Project Consultancy. He has experience of construction methods and building use types, both in design and project management. And thirdly, I've got David Watling, Head of Commercial Property. David's been involved in all aspects of commercial property for over 30 years. So let's kick things off. What are permitted development rights?
Permitted development rights allow certain works to buildings or to land without going through a full planning application process. So that could be Class Q, which might be agricultural buildings being converted to dwellings, or Class R, being agricultural buildings converted to commercial flexible use types. There are lots of permitted development rights within the planning framework, and those are two agricultural types that we're probably going to focus on today. But there are a number of types for works to domestic buildings and various other types which we can advise on.
Yes, thanks for the opportunity to clarify more about permitted development rights, which we are going to be referring to as PDR. So just to add on to what David has said, this is a mechanism that was introduced by the government to try and simplify the planning process. So where you would normally apply for full planning permission, the government has introduced a simpler way of obtaining approval. Although it's not called a full planning permission, it's called prior approval because the government has introduced this system whereby there's deemed permission. So deemed permission means it's already accepted that a development can occur, but you got to go through a certain process which is called the prior approval process, and there are prior approval matters that have been listed in each of the relevant sections of the permitted development rights. Prior approval matters like flood risk assessment, transport assessment, and there are a number of prior approval matters. One doesn't have to go through the whole process that you'd normally go through when applying for planning permission.
So does prior approval, is that applicable for PDR as well? Is that what you're saying? So you'd go through prior approval for both PDR and full planning?
No, the prior approval is specifically for PDR.
Okay.
Full planning permission is whereby the council is actually looking at the full planning merits and they apply the council policies and the national policies. Whereas with PDR and prior approval, the council has only to look at those specific matters cited within the relevant section of the permitted development rights. For instance, under Class Q, which David alluded to, which is the change of use of agricultural buildings to residential, there are prior approval matters that the council will be looking at. So if you satisfy those prior approval matters, then prior approval would be granted. Whereas with planning permission, the council will have to look at the council policies and the national policies that are applicable to that particular development. So the main difference here is that with prior approval, with an application for prior approval and a full planning application, is that the only policies that can be used in a prior approval are those that are specific to the prior approval matters. The council cannot introduce any other policies which are not relevant to the prior approval matters.
So with some permitted development matters, there are permitted development rights which do not require prior approval, and then there's a threshold at which prior approval becomes required. So each permitted development right has different sets of rules So there's lots of small print.
So how do you know then, if you, for example, if you're you've got an agricultural building and you want to change it into a dwelling or commercial, and you kind of look at PDR and you think, oh, actually my project ticks the box. How do you know what would be the next step?
Well, the next step really is to speak to an expert and check small print, because, as Abel said, there are limited grounds to which the council will be assessing a project for prior approval for, say, Class Q or for Class R, so that's agricultural to residential or agricultural to commercial.
Yeah.
And those rules are different for both sets of, for commercial or for residential, they're different rules. So assess them, and then effectively it's preparing the evidence to be submitted with an application for prior approval to the local authority to get the certificate effectively, to go through the process of providing them evidence to show compliance with those rules, and upon compliance, approval is granted.
And then I guess once approval is granted, you can just start
No.
straight away. Okay.
No. Right, so with Class Q, which is agricultural to residential, that gives you consent. They can put conditions on, and that will sometimes require conditions to be discharged. However, with agricultural to commercial, which is Class R, the prior approval gives you the change of use. It does not allow any alterations to the building itself. If you're doing any alterations, which might be putting a shutter door, re-roofing it, recladding it, altering the layout, putting windows in, etc., that requires a full planning application to follow up from the granting of the prior approval for the change of use.
Right.
So it's a two-stage. And then once you've done that, there might well be conditions to be discharged possibly. And there's also other legislation that you need to be aware of in terms of building regulations and Party Wall Act, etc.
So if you are looking to change your building to commercial, why go down PDR first if you're then going to have to do a full planning?
Because, as Abel explained earlier, if you went for full planning for a conversion of an agricultural building to commercial use, you would have to review all of the national planning policies and local authority planning policies, and you would probably find that you don't comply with those policies. The policies in general, each borough and each authority is different and has different policies. And there's also neighbourhood plans which introduce policies. But in general, the policies tend to restrict development to designated areas where surrounding towns or on industrial estates and the like, whereas we're really talking about agricultural buildings in the open countryside, which are perfectly good for commercial use, but would not be favourable and would not comply with national government nor local authority local plans.
So once you've got prior approval and then you have to do a full planning application, the council would treat you completely differently. Is that what you're saying?
Absolutely, because
Right.
you've got the principle of the use.
Yeah.
You're then looking at the specifics of what needs to be adapted to the building. Going that route gets you the principle, and and the principle is 95% of what matters in respect of a planning application.
And I would suggest that at the same time, if not before, the parties need to consider the cost of conversion, because if the costs are prohibitive, allied to the income that might be generated and the capital value that will result, it may not be economically viable to carry out the development in the first place.
Absolutely. That really is step one, is looking at what is the converted unit worth compared to how much it's going to cost. What's the payback?
What's the agricultural value that sits alongside the conversion value?
Correct.
Having established the principle of the development, which is very important, because a lot of the policies are quite restrictive when you are looking at development in the open countryside. So most sites in the countryside are considered to be unsustainable for new development, and also you'll find that you cannot actually because those sites are probably not designated as within the settlement envelopes where development is preferable.
Mm-hmm.
But then because of these PDRs, which I've referred to as deemed permission, you are skipping that stage of trying to contend with those restrictive policies in the countryside, because the government has already said, well, development is appropriate in the countryside regardless of the restrictive policies, the national policies, the neighborhood planning policies, and the local planning policies. So we would recommend that we are given an opportunity to assess whether whether the site can actually benefit from those permitted development rights, because a lot of people might not be aware that their buildings or their sites can actually benefit from those permitted development rights.
I see. So if anyone comes to us saying, I want to convert my barn or property or commercial unit or do some kind of change of use, we would actually assess the project, and they may not have even thought of permitted development rights, but we will have a look, do a site appraisal, and obviously advise whether they need to go down PDR or the full planning application.
Absolutely. That's absolutely right. There are a number of, there are lots of commercial uses in agricultural sites and in agricultural buildings where people have just got on and done it without consent. Where that has occurred and it's been in situ for more than 10 years, there is a potential opportunity to get a certificate of lawfulness for those particular sites, because David will, I'm sure, allude to this and provide some figures in terms of the benefit of having the correct permissions in getting a long-term tenant.
Yes, indeed. There are a number of storage buildings, agricultural storage buildings locally that we have let and other agents have let over recent time. None of them will have the benefit of planning permission, but there are a number of tenants that are desperate for space. There is a shortage of space, and they're more than happy to take an agricultural building for storage purposes. One of the main benefits is the fact you don't pay business rates, which is very attractive. You're paying, in effect, just the rent with no other overheads other than utilities. But yes, if you do get PDR and you convert the building in a proper way, you will get an enhanced rent, undoubtedly, which could be attractive to you, allied to the initial outlay.
And also, if I can come in, you raise a very interesting point, David, about carrying out works before you actually apply for permitted development rights. Actually, it's something that we would not recommend, because prior approval strictly means you got to apply before you actually do the works. Otherwise, you are disqualified from the prior approval process if you go ahead and do the conversions without first going through the process, which will then take you to the 10-year period that David has mentioned. So, whereby you could have benefited straight away from permitted development rights, you are then having to wait for 10 years. But then 10 years, that's not a guarantee, because already if you go ahead and do the conversion before you get the approval, you might be liable to enforcement action by the council. So within the 10-year period, the council can actually take enforcement action. So it's not something that we recommend, which is why we would always encourage landowners to get in touch with the experts, and then we do an assessment, because there are so many restrictions. For instance, if a site is in the area of outstanding natural beauty or is close to an airfield or airport, that might place some restrictions on what can be done or what can't be done. So there are those kind of issues that we may need to look into before we recommend which route would be most appropriate.
Okay, thank you, Abel. So just going back to PDR, are there any changes that we're aware of that might make it less, not as easy or more easy?
There have been recent changes to permitted development rights for Class Q, changing the number of units you can convert and the areas or floor space that you're able to convert. So that's recently been introduced. That has changed the dynamic a little bit. It's opened up the potential to convert more buildings potentially with the additional number of units for residential property, for agricultural to residential properties. There's also been changes to the floor areas that can be converted for commercial. So they're the recent changes. We don't know what might come with the recent election result and the Labour government coming into force. We suspect there may well be more changes to come. There's particular talk about grey land, whether that's going to have an impact it will have an impact on the planning process and development, and there may well be changes that the government make to permitted development rights with their objective of trying to kick more development into gear.
Thank you, David. What if your PDR application is refused entirely? What's next for the client?
Okay, if the PDR application is refused, obviously we need to understand first the reasons for refusal. And if it's such that we can repackage the application and resubmit, then we would recommend taking that route. But at times, you look at the reasons for refusal and you say to yourself, well, it doesn't help to repackage the application because maybe we are actually in disagreement with the council on matters of principle or on matters of interpretation of the regulations. So in that case, we then recommend that we test the council's decision on appeal. So we challenge the council's decision through the Secretary of State, who will then appoint an independent inspector, so to have a fresh pair of eyes looking at the council decision. So we prepare our arguments and then exchange arguments with the council, and then the independent inspector will then deliberate on the case.
Yeah, we had one appeal that is very memorable to me, where the local authority, in determining a Class R application, which is agricultural to commercial, used the Class Q rules to try and determine it and refused it, which we appealed successfully and also won costs against the council because they used the wrong set of rules.
David Watling, you've touched on rental yields and obviously making sure that you are aware of the costs before you proceed. Do you have any specific examples of what kind of a rent would be achieved?
Well, indeed. I deal with it in two aspects. One for sort of the storage stroke industrial buildings and one for the office sector. Now, as we all are aware, following COVID, the office sector has struggled of late, but we are seeing initial encouraging signs during the early part of this year anyway, of companies bringing staff back into the office and making decisions as to their future office requirements, whether it's downsizing or indeed having a larger office space. But the cost of conversion to office is an expensive matter, and in a lot of instances you'd probably not want to carry out those works until you knew you had a tenant lined up prior to undertaking the works. The likely income you would generate on a square foot basis, I'm going square feet, not square metres by the way, would be in the order, and it depends where it is and how large it is, but in the order of £14 up to about £18 per square foot per annum. And I'll be totally honest, I think if you weren't achieving anything of that order, it probably wouldn't be economically viable to carry out the conversion works in the first place. Storage buildings, a lot less cost. David alluded earlier, you may have to put in a shutter, you may have to put in toilets and perhaps a small office or kitchen area. But if it's storage only, you're not really looking for staff to be there between 9 to 5 anyway, coming at the beginning of the day and perhaps the end of the day and whatever. The likely level of rent for that, again, depends on size and where, etc. But you would be achieving something in the order of £6 to £8 per square foot. If it didn't have consent, we talked about this earlier, if it was an agricultural building that didn't have consent and perhaps wasn't in as good order, you would still achieve something in the order of £4 a square foot based on current experience, but nowhere near £6 to £8 per square foot that we would achieve with the benefit of the permission.
Okay. Thank you, David. So we've talked about the process, and obviously it's quite clear that PDR does make it easier for clients when they're looking to change the use of the property or do any refurbishment work. What kind of length are we looking at in regards to the start of contacting us to when they're likely to have a successful outcome?
It really depends on the type of application. Residential versions will take longer and quite often involve potentially bat and bar nail surveys and can also involve needing a preliminary ecological appraisal. But if we're talking about a Class R agricultural to commercial building, then we're looking at a relatively simple application, maybe something like a portal frame building in a agricultural yard. Then we would go out and survey the buildings. We would need to produce a site plan, location plan, floor plans, and we'd normally do some elevations to keep it straightforward, but that's not absolutely essential. Then we'll be talking about getting the package prepared within 2 to 3 weeks in terms of drawings and the planning statement, submitting it to the local authority, and they require just over 8 weeks to determine it, 56 days to be precise, in order to get a decision. So yeah, that's the general time frame. The other thing I would just add in, we haven't talked about what's quite often known as the Clarkson's clause, which is for smaller buildings, less than 150 metres squared, which again, we talked about whether you need to do prior approval or whether it's permitted development. Well, with Class R buildings of under 150 metres squared, the first 150 metres squared, should I say, then you can do a notification to the local authority to tell them that you're doing the conversion rather than to ask them for consent.
Right.
Yes, just to add on to what David has just explained, after the expiry of the 56 days, if the council has not made a decision, then it's considered that by default you've got the approval. But then one has to be very careful about what the next step is to take, because even where you are granted prior approval, it does not necessarily, this is where it becomes a little bit tricky. It does not necessarily mean that the development is lawful, because that is a completely separate question. So in certain instances, it would be advisable to apply for a certificate of lawfulness to verify that the development is actually lawful. So, I mean, it's not...
Give an example on that one, Abel.
An example that I can think of is, say you get prior approval for the conversion of an agricultural building to residential, and then you go ahead, you implement on the basis of the prior approval, because remember from the start we said with PDR, where you have to follow the prior approval process, that is sort of a closed process whereby the council is only looking at the question of whether the application is complying with the prior approval matters, which are listed from 1 to whatever, maybe 5. So it's like a tick box exercise.
Mm-hmm.
It doesn't look at anything else. It doesn't look at the lawfulness of the development. It might happen that probably the council has actually confirmed that the prior approval matters have been satisfied, but however, the development was not in fact supposed to have been considered under Class Q, because perhaps there was an Article 4 direction which prevents that development from happening. But
maybe the building had been used for commercial operations as the last operation, which is again a reason that potentially a class Q shouldn't have been applied.
Yeah.
But how would you know as a client?
You don't, and that's why I think Abel is saying to be very risk averse, you get the prior approval and then apply for a certificate of lawfulness. That is being quite risk averse, and not many people would do that, but that would give you absolute assurity.
Yes, that's correct, and that is also why we recommend that landowners should contact us to do some kind of sense check.
And this is obviously only applicable for those that are converting to dwellings, because with commercial, you go down the full planning application route.
It applies to everything.
Okay.
Yeah, because even under Class R, the council is only looking at the prior approval matters, and the prior approval that a developer might get at the end of the process. Again, the same principle applies. It doesn't certify that the development is lawful, but of course, you are right in a sense, because with Class R, you then have to go the next step, which is to look at the operational development. But take for instance, if you've got a building which land is sort of readily convertible without even going to the next stage. So if you pass the first stage, then there might not be a requirement to apply for the operational development, because the building is already in a state that it can be converted.
I see. So really the process is to obviously do prior approval, get a certificate of lawfulness, and then obviously depending on the project, you might need to go down a full planning application route. However, we would be able to advise.
Yes, if you want to be risk averse.
Yeah.
I think most clients would feel satisfied that they have a certificate confirming that prior approval has been achieved and that prior approval has been granted. There are examples, and where, for example, as we said, if a building had been used for maybe commercial use as the last operation in the building, and then a Class Q or a Class R application had been made, in theory, you're not allowed to do a Class Q and a Class R if the building was last used for the commercial use. It's only applicable for agricultural buildings. So in theory, that would make the prior approval an unlawful process. So Abel's absolutely right on that. However, what we see practically is that most clients are satisfied once they've gone through the prior approval process.
The other thing I would also want to mention is that the client might actually be satisfied with the prior approval, but then when it comes to conveyancing, say if the client wants to dispose of their building with prior approval, there might be maybe, say, lenders from the other side would actually say, could we have proof that this is lawful? They might not be satisfied with just the prior approval, but they may want also the certificate of lawfulness.
Yeah, I guess with anyone they can go down that road if they need to, or is there a duration of time that they have to apply for the certificate of lawfulness?
No, there's no time limit for a certificate of lawfulness. You can apply at any stage from the time that you get the prior approval.
Okay.
Other than obviously if the time limit on a planning application is elapsed, then you can't apply for prior approval having not, if the development hasn't been carried out.
What is the time lapse once you get prior approval?
It's 3 years.
Okay.
Because you've got to implement the prior approval works within 3 years.
And for Class Q, that means complete the conversion works and development, and for Class R to have implemented the use within that 3 years.
So for Class R, if you go for the next stage, which is to apply for the operational development, which is the structure itself, then you get the 3 years from the time that you get the second stage approval.
Okay. I think we've covered quite a lot in this podcast so far. If you do have any questions, then Abel, David Sawford and David Watling's contact details are available on our website. Thank you for listening to our Permitted Development Right podcast today. I am going to be launching a series of podcasts. They'll all be available on all the popular podcast channels and our website. Please stay tuned, and there'll be lots of topical subjects. There's also podcasts that we've already recorded available on those channels as well. So have a flick through. There might be something else that you'd be interested in listening to. We will be launching a range of podcasts in order to share our experts' opinions on a range of matters. If you do want to contact them, have a look at the Meet the Team page on our website. If you've got any questions, you can either give them a call or send them an email. Thank you for listening. Please comment, engage, stay tuned, and I'll see you again soon.